Permit me to set out what was reiterated in that decision. The real question is whether reasonable apprehension of bias was presented, which would make an informed and fair-minded person seized of all the information surrounding this matter and the impartiality required of judges by their constitutional oath apprehend bias on the part of the bench. Now, what is the information surrounding this matter? Let us start with the case of Honorable Justice Freda Mugambi. The charge in respect of which recusal is sought is that she was an LLM student of Professor Ndegwa. It has been demonstrated by facts which are not in dispute that the Honorable Judge was not an LLM student of Professor Ndegwa in the Moi University or any university, but instead her LLM was obtained from the University of Birmingham. It is as simple as that. Issue number two, that Madam Florence Onwuch was appointed to a board by His Excellency President William Samoei Ruto. What are the facts? Madam Florence Onwuch was appointed to the board by Soipani Tuli. These, my lady and my lords, are the facts upon which information surrounding this matter are to be determined. The next authority which we rely upon is the case of Eli Valley Mines versus Lee. And the principle set out in that case is as follows. In this context, the reasonable person is not someone who is hypersensitive or unduly suspicious, but rather a well-informed, thoughtful observer who understands all the relevant facts and has examined the record and law. Now, insofar as Honorable Justice Freda Mugambi and Honorable Justice Eric Ogola is concerned, has there been demonstration on the basis of a reasonable person who has examined the record and the law to demonstrate that there is bias, real or perceived? That is the question that this court must answer. What about Honorable Justice Anthony Murima? The charge is that the Speaker of the Senate, the Right Honorable Amason Kingi, attended his wedding. My lady and my lords, there must be meaning to the term learned friends. There are those who have written, including a writer by the name Jess Brayley, a book titled Lawyers and Other Reptiles. And there are those who have also written, including Feroz Norji, practicing an honorable profession. Indeed, we are learned friends. A judge is first an advocate and second, a judge. A judge does not reside in isolation. And if I may just say, for example, I've had a cup of tea with Justice Anthony Murima. I've had a cup of tea with Justice Eric Ogola. I've not been fortunate enough to have a cup of tea with Justice Freda Mugambi. Well, they are my friends. But I appear before these courts and they rule in favor or against me. It is in that context that we must examine. Is the charge against Justice Anthony Murima one based upon information in the mind of a reasonable person who has reviewed the record of the facts and the law? And if your lordships and my lady will return a negative answer so far as these questions are concerned, then you must make a decision whether to recuse yourself or to continue handling this matter. It is my humble submission, based upon what you've said, that there is considerable doubt as to whether a case has been made out to warrant recusal. We request this court to dismiss this application. I'll allow my colleague to utilize the remaining 2 or 1 minutes to say something.
my lords and my ladies, Mishuki for the Law Society. My lords and my ladies, I will start off by the submission, clarification of the submission.
Is that whatever the respondents have gone to misconstrue and misconceive the applicant's case. Your Lordship, in respect to the relationship that were drawn, both for the presiding judge and Justice Mrima, the charge is that of deliberate failure to disclose the relationship. That my lords, you are aware at the time of the inception of the case that Justice Mrima is closely associated to one of the parties, but he deliberately failed to disclose. Equally well, the presiding judge was well aware at the inception of the case that his spouse is greatly connected to some parties in the proceedings, but again failed to disclose.
You should not tell which parties. You say clearly, if you can't understand what you are doing, please go to your affidavit and read the affidavit again.
My lord, I then
reply on matters of law. I will not allow you to misrepresent facts. You have an affidavit.
And to embarrass the legal profession.
Yes,
Your Lordship,
you have an affidavit, Mr. Ndegwa. If you can't understand what we are talking about, verbatim, read verbatim from your affidavit.
Your Lordship, may I draw your attention to paragraph 74 of the judgment of the ruling in Havi. The judge says that due to the failure to so disclose on the part of the third respondent, it has led to an erosion of the confidence and the applicants have that will be neutral when it comes to the hearing and the determination of the arbitration. That, Your Lordship, is a confidence that has been eroded. On the question, Your Lordship, on the duty to sit, the duty to sit must be accompanied by transparency and accountability to the parties appearing before a judge. Your Lordship, the duty to sit and the oath of office taken by a judge or a judicial officer must be executed in a manner that breeds confidence to the parties that appears before a judicial officer. Lordship, it's our humble submissions that confidence has been eroded. Your Lordship, the arguments by Mr. Nyamondi that the parties are forum shopping. Your Lordship, this bench was constituted pursuant to Article 165, Clause 4 of the Constitution, and no petitioner herein has the capacity to direct the Chief Justice who constitutes the bench as to which judge to sit in a particular bench. There is no possibility, Your Lordship, therefore, for an argument that parties are forum shopping. At the inception of the proceedings, Your Lordship, we appeared before you and made arguments comfortably. Little did we know that we would be faced with an application of this nature due to the failure of the honorable judges to disclose those material facts. I invite Kibe to proceed.
My Lord, while during the course of, I guess we've been here for about 5-6 hours when this application has been going on, and there are two things that have been crossing my mind. My Lord, the first issue is the issues of substance, and the issue of perception, the optic.